Hey there, this is Anne Marie coming at you as the Anti-HR HR lady. And today I want to talk to you about a very important workplace rights law that you probably don't even know exists, the Fair Labor Standards Act, or the FLSA. But before I do that, I wanted to talk to you a little bit about why I have been spending the last several weeks talking to you about workplace rights laws that I think you need to be aware of. If you've been paying attention over the last 3 weeks, I talked to you about the Americans and Disabilities Act. Before that, I talked to you about the Age Discrimination in Employment Act, and I also talked to you about the Family Medical Leave Act. And the reason that I'm highlighting these different laws is because there is about 10 workplace provisions that are kind of the cornerstone of the foundation of all the employment rights that you have in workplaces across the United States. And I think it's very important that employees, especially Black employees, and particularly Black women, know about these laws, know they exist, and know what they mean and what they are. So over the next several weeks, I'm going to be talking about several of those key laws that I think are important for most employees to know about, because it's very clear to me as I continue to talk to people on discovery calls that, one, most of you don't even really understand what discrimination actually is. And I've done videos explaining that, and I'll link one here to remind you once again about what discrimination actually is. But it's also very clear that many of us don't know about these workplace laws. We may know that there are policies that our employers have and things that our employers have to do or not do, but we don't necessarily know why. And I think it's very important for employees to not know just what, but why, right? Because the reality is, from a historical perspective, that every single workplace right that Americans have, somebody fought really hard and somebody probably died to get them, right? And so it's very, very important that you know that these rights exist and what they mean for your workplace, right? And that way you know when your employer is not following the law and not enforcing these rights via policies in your workplace in the way that they're supposed to. So I really think it's important that you guys pay attention to what I'm saying to you. Read the blog posts that I have written on my website. If you're not subscribed to my website, I really encourage you to do that. And really acquaint yourself with these laws, because employers really do rely on your ignorance in order to take advantage of you. And so the more information you have, the more knowledge you have, the more formidable you are when you come to assert your workplace rights, right? Because as I said before, it's important for you to know this. People literally struggled, fought, and died throughout the history of this country. People have had to fight for these laws to happen. There's always been a small group of white, rich men who have taken advantage of everybody else, have pitted people against each other and taken advantage of them so that they could be richer and richer. If you think that means that I don't like white men or white people, don't, take it however you want. Don't argue with me, argue with history. I can only talk about what the facts are. And that is the reality. Throughout history, a small percentage of people who are very wealthy, who are primarily white men, have instituted behavior and actions that have taken advantage of pretty much everyone else. And so a lot of these laws had to be passed in response to the exploitation of workers. And that's all workers, white, black, yellow, orange, whoever they were. These laws were passed to protect workers throughout history. So it's very important for you to understand history and to also understand the impact and the importance of these laws that I'm talking to you about, so that you know how to assert your rights and that you better understand the policies and the procedures that are in place in workplaces across the United States, and understand that anything that your employer gives to you, they're giving it to you because there's a law that says they have to give it to you. They're not giving it to you because they're nice people. They're not giving it to you because they care about you. They're giving it to you because there is a law that says that they must. And in many cases, even though there's a law that says that they must, they try to find ways to get around those laws and to skirt those laws. So it's really important for you to know what the laws are that are the foundation for your workplace rights and a lot of the workplace policies that you are going to see in your handbook. And as I always say, Read your employee handbook. They gave it to you for a reason. You need to know what's in it. So now that I've, prefaced that a little bit, let's talk a little bit about the Fair Labor Standards Act of 1938. So the Fair Labor Standards Act of 1938 is a crucial safeguard against exploitation and unfair labor practices, and it sets the standard for minimum wage, overtime pay, child labor, and record keeping. Its significance transcends time, making it imperative for every employee to understand the provisions of this law. Now, what you need to understand about the FLSA is that it was introduced to address rampant exploitation of workers during the Great Depression. Its primary objectives are to ensure fair compensation for labor, protect the rights of workers, and regulate employment conditions across various industries. And by establishing these standards for wages and working hours, the FLSA aims to promote economic stability and social justice. It's one of the most important laws that most employees don't know about. It's the reason why there are things such as exempt and non-exempt employees. It's the reason why there are things such as overtime and overtime pay. It's the reason why they're not 9-year-olds working next to you in the office. Okay? That's because of that law. So here are some key provisions of the FLSA that you need to know about. Minimum wage. The FLSA mandates a minimum wage currently set at $7.25 per hour to safeguard employees from substandard pay. Now remember, the hourly minimum wage is the federal minimum wage. Most states have minimum wage that is above the federal minimum wage. And I will just say as an aside that I find it shocking that in 2024, the federal minimum wage is still at $7.25 an hour. I know California just passed a minimum wage of $20 per hour, and employers are yelling and screaming, but they'll survive. $7.25 an hour, even $20 an hour is not a living wage that people can live on. And I just find it shocking that citizens of the United States are willing to put up with a government and a system that allows a minimum wage of $7.25 an hour. I just think it's outrageous, right? While rents and the cost of living, there's no way that you could live on that. So as I said, most states have a minimum wage somewhere between $12 and $15 an hour, which is still not even at pace with inflation. But the federal minimum wage at the current time is still $7.25 per hour. The second provision of the FLSA is overtime pay. Employees are entitled to receive overtime pay at a rate of at least 1.5 times their regular hourly rate for hours worked beyond 40 hours per week. Now, it's important to understand that the employees that are entitled to overtime pay are employees that are classified as non-exempt under the FLSA. That means they're not exempt from the FLSA requirements for overtime. Employees that are exempt from the FLSA requirements do not get overtime, and those employees are usually classified as exempt and salaried employees. This is the reason why so many employers will make a chicken sandwich a salaried employee. They don't want to pay overtime. So a lot of times they will misclassify positions in order to not pay employees the overtime that they should be paying them. So it's an important thing to understand when we talk about overtime pay, what that means. The third provision under the FLSA is around child labor protections. The Act places restrictions on the employment of minors, safeguarding their health, education, and overall well-being. A little known American history fact for many of you may be that before this law was passed, children were working. They were out here working in the fields, working in the factories, getting killed and dying in factories alongside their parents. Because of this law is why there is a rule about hiring and having minors work who are under the age of 16. There are also rules around minors between the age of 16 to 18, right? In every state in the United States. Now, of course, recently, Arkansas passed a law loosening their rules around child labor because, there's a certain political party and sector of people in this country that would be happy to probably have 9-year-olds working because they don't want to pay anybody a minimum living wage. And an easy way to alleviate, that is to put children back in the factories. And some of them would do it if they could get away with it. So it's really important to understand why it is that there are protections for children relevant to labor, and their limits around how old they can be and so on, and the fact that they need to be in school and not in the factory. Again, all of these things are because of laws that were passed that people had to fight for. No one gave this out of the goodness of their heart. And you won't keep it if you don't know it exists and you're not willing to fight for it as well. So now that I've explained really quickly a general framework for the Fair Labor Standards Act, or FLSA, and I've explained what the key provisions of the act are, let's talk about 3 ways that employers will violate the FLSA that you need to pay attention to as employees. So 3 major ways that employers will violate the law are as follows. The first one, and the most popular one, is misclassification of employees. As I just explained, there are employees that are non-exempt from the provisions of the act, and there are employees that are exempt. So many employers will intentionally classify employees as salaried or not or exempt who should be classified as hourly and non-exempt simply because they don't want to pay them overtime. And this is a huge problem in retail, as well as nonprofits are huge offenders, and corporate America, right? But I've seen huge abuses of this law in the nonprofit sector. As you know, I spent a lot of time in the nonprofit sector in my professional life. And as an HR professional, I had to spend a lot of time educating management about their responsibilities under this act. And as I told in another video, I spoke of how one person literally told me that they didn't have to follow this law, that it was for people who worked at McDonald's. But I'm here to tell you that the Fair Labor Standard Act applies to all employers who fall under the act, right? And so you don't get to decide that it doesn't apply to you just because you don't want to follow it. Another way that employers intentionally violate the FLSA through misclassification is to classify employees who should either be classified as exempt or non-exempt as independent contractors. By classifying employees as independent contractors, it allows the employer to exempt themselves completely from the requirements of the Fair Labor Standards Act. So this is one that you really need to look out for because it is rampantly abused by American employers across the board. They will hire someone, classify them as an independent contractor, when in fact they should be classified as a regular employee who's either hourly or salaried, non-exempt or exempt. I have done a video before about independent contractors and misclassification, and I will try to find it and link it. If it is not linked on this channel, then I'll do another video about this subject because it's very important for employees to know whether or not they should in fact be hired or accept being hired as an independent contractor, when in fact they are actually should be hired as an employee who is either hourly or salaried. Employers are really slick on this one, and they are always using it to try to get around paying salaries, paying overtime, giving benefits, and so on. And the way that they do that is by classifying someone as an independent contractor who should in fact be classified as a regular employee who's either hourly or salaried. So do look out for that misclassification trick as well. The second way that a lot of employers abuse the FLSA is unpaid overtime. Failure to compensate employees for overtime work is a common violation. So if you are classified as an hourly employee who is non-exempt and supposed to receive time and a half, as we call it, and you're not getting your time and a half pay, or your employer is behind on paying it, that's a violation that you can report them for. The third way that employers often violate the FLSA is off-the-clock work. Employers may pressure employees to work off the clock or during breaks, denying them their rightful compensation. This is another thing that often happens in retail or places where there are a lot of hourly workers, factories, and so on. And it's something that employees really need to pay attention to and be aware of. You're not supposed to be told to work through your break. You're not supposed to be denied the compensation that you're supposed to receive as an hourly non-exempt worker. So what do you do if you think that your employer might be violating your rights under the Fair Labor Standards Act, or FLSA? You're gonna, you know what I'm about to tell you. The number one thing you need to be doing is what? Document everything. Keep detailed records of your hours worked, your pay statements, and any instances of potential violations of FLSA. It is incredibly important that you document everything. And I have created the Anti-HR Documentation Journal to help employees to document effectively. It provides prompts, it provides information about not just what to document, but how to document, and gives information throughout the documentation journal about things that employees should document and how to go about doing so. And it's right in there. You can download it, and there's places right in there to type the information in, or you can print it out and write in it. But it's very important that you have a clear documentation process if you believe that your employer is violating your FLSA rights, because you not only want to show that they're doing it, but you want to show that they've been doing it over a period of time and a pattern of behavior. That would be very helpful. So please document everything that happens if you believe this is going on. The next thing is generally to educate yourself about the laws relevant to this, as well as understanding what to do if you believe that your employer is behaving illegally and you want to exercise the option of leveraging that knowledge to have them pay you to leave your workplace. I have a training called How to Ask for an Exit from a Discriminatory Hostile Workplace with Cash and Actually Get It, and it will equip you with all the information you need to have to understand what to do once you have effectively documented in order to leverage your employer's illegal behavior and turn it into a negotiated separation with severance. My online course is currently on sale for $399. It is marked down from $599, which is the regular price, and it will be on sale until April 30th. Thereafter, it will go to its regular price, probably until Black Friday. So I suggest that you take advantage of this spring sale, because once it's over, it's over. Don't come in my email box, y'all. Some of y'all have already done it after the Black History Month sale was over, asking if you can get the sale price. The answer is no. When I do a sale, if you know that you need this information and you want to take advantage of it, take advantage of the sale. Because I don't do that many sales each year. This is the first year I've done a spring sale, and depending on how people respond to it, I'll decide whether I'll do another one in the future. I always do one for Black History Month, and I always do one for Black Friday holiday season. So if this is information that you think is important based on your workplace situation, take advantage of the sale and access the information that you need. When your employer is behaving illegally, you can use their illegal behavior to leverage and cash out of your workplace. Through this course, you will learn how to leverage your employer's illegal behavior to ask for a negotiated separation with severance. And this is really important for those of you who believe that you are working in a discriminatory, hostile work environment. So if you know that you would like to take advantage of this information, please take advantage of it while it is on sale, and it will be on sale until April 30th. The third thing that you can do is to contact me, the Anti-HR HR lady, through a discovery call. You can visit my website, you can book a discovery call. I'm happy to have a conversation with you about what your situation is at work, and we will assess it and then determine whether or not I think I can help you to navigate whatever the situation is, whether it's a discriminatory hostile work environment, or it's a performance matter, or a PIP, or whatever it is. But if you believe that your manager or your employer is violating your FLSA rights and you would like to know what you can do, feel free to book a discovery call with me and let's have a conversation. Another thing that you can do is you can report the violations of the FLSA to the Wage and Hour Division of the U.S. Department of Labor, and or you can seek legal counsel to help you to do that. That is always an option, right? But again, I really think as an employee, you have the ability to actually do this yourself without having to go through those steps. So I always advise employees, if you know that you're in a situation and you want to leave, you can actually navigate that on your own without having to file a complaint or hire an attorney. But if you go through the steps necessary to navigate out and your employer is one of them who are not very smart and decides that they don't want to work with you, then filing a complaint and reporting the violations is something that you should definitely consider doing to hold them accountable. Because at the end of the day, to me, the most important thing is holding employers accountable for their bad behavior. So that is a quick overview of the Fair Labor Standards Act. I think it's a very important law for employees to know that it exists, why it exists, and how it applies to them in their work life. So whether you're a salaried employee or whether you're an hourly employee, the Fair Labor Standards Act is a law that you need to know about. So please keep this in mind. Please reach out to me if you feel that your employer is violating your rights under this act. Please also read the blog post that I have written about the Fair Labor Standards Act so that you have a clear understanding of what it is and how it works. I hope that the information that I have shared in this video is helpful and that it will help you in building your knowledge about knowing what your workplace rights are so that you can be an educated employee who's ready to assert your rights if they are violated. As always, I'm Anne Marie, the anti-HR HR lady. HR is not your enemy, but they're definitely not your friend. I am. I'll see you guys in the next video. Bye.